we'll just go down the line that applies for all of them. So the owner has to furnish a notice of claim, reasonably detailing out what the defects are. So assuming that they're in contract with the GC, they don't have to serve it on their subs, they serve it on the GC. And they reasonably detail out, say, whatever the problems are. Now, I recently received a notice of claim this way, and we're going to get into the next one. Once the GC gets the notice of claim, they then have 10 days to turn it over to everybody who they think may be responsible. So what should the GC be doing to cover himself? Send it to everybody that he knows. Does everybody know what CYA means? Call your attorney? You know? You send it to every person that you think down the line who the GC may have hired just to protect themselves. Because if that person didn't receive that notice of claim, they may not be in the loop. And it may delay proceedings later on because they didn't get notice of all of these defects. From there, so now the GC has given the notice of claim over to all the subs and all the people who it hired and thinks that may be responsible for these defects. For instance, it may be the pool, it may be the electrical, it may be whatever else. Well, that person that receives it from the GC then has 30 days, well, everybody really has then 30 days to go to the project, inspect the project, and look and see what's going on. Well, usually everybody's real good. I've never had this as being a problem. Everybody's usually really good about those time frames and about extending those time frames. If everybody's trying to work towards a solution, nobody really wants to be embroiled in a lawsuit. So everybody's trying to work to get this thing resolved. So we all look at so even though it says 30 days, people are real good about that. And what will happen is there's a free exchange of information, expert reports and everything else like that can be relied upon. And from there, there's 45 days, or really really 15 days from the day that you're strike that. You have 45 days from the recipient receiving the notice of claim to give a written response. Okay, so you received it. You have 30 days to get out and inspect it, and then from that same time frame, from that receipt date, you have 45 days to actually give a written response. Now, the written response can say, 1, it's not warranted. 2, I don't think I'm responsible for it. 3, I will fix it. 4, I think I'm partially responsible. 5, I'll give it to my insurance company, let them take care of it. 6, you don't respond at all. However you're going to respond, if you don't respond at all, then you're deemed to have denied it anyway. But then, I don't want to be on that side representing you because you had your chance, and it's going to look like you're really the person who's not trying to work in good faith. What happens now if you do not serve this, if the owner does not serve a notice of claim upon you, detailing out the reasonable defects? Well, I'll tell you, I just had a case last week, and I do this all the time. We file if I'm representing the contractor, it's already pre-printed. I've written this thing so many times. Motion to abate the case for failure to comply with Chapter 558 until this precondition happens. Well, I have one case where the owner went ahead and fixed everything, never gave the 558 letter. I filed it. That case is still abated. It's been 3 years. They're never going to be able to do anything. How are they going to get us to come out and inspect what they've already fixed and give us an opportunity to respond to it? They can't. That case is gone. All right? The other one is like the one that's going on right now that we just argued last week. We filed a motion to abate the case pending compliance with the Chapter 558. They give us back a letter. Here's our notice of claim dated September 22nd. The pool and the fountains don't work. Wrote them back. They compiled a bunch of things, and it was the pool and the fountains don't work, and the parking lot pavers also don't work. So I wrote them back saying, tell the unit owners of your apartment building to stop parking in the pool and swimming in the parking lot. And you need to give me back a better and a more reasonably detailed out notice of claim, because I don't understand what you're talking about. The pool's a pretty big pool. So